Well, good morning, everyone, and welcome to a morning session of oral argument in the 5th District Court of Appeal. As you've already heard, I'm Judge Griffin. To my right is Judge Sawaya, and to my left, I am pleased to say we have with us today, as a visiting judge from the 7th Judicial Circuit, Judge William Parsons. We have a mixed bag of civil and criminal cases today. I'm sure you all know that the criminal cases have 15 minutes to decide and the civil 20. There is a clock on the podium that will help you keep your time. And if anyone would like me to assist in giving you a high sign to reserve some time to rebuttal, just let me know. We'll call the cases in order today. The first case is Smith v. State, and counsel can begin when you're ready.
Good morning. May it please the court, my name is William Pennell and I represent Michael Smith, the appellant in this case. I would request that 5 minutes of my time be reserved for rebuttal. In this case, there were 4 alleged violations of probation, and the trial court found that Mr. Smith had committed all these alleged violations and sentenced him to 12 years in prison based on all 4 of these violations. Unless this court concludes that the state established that Mr. Smith committed a willful and substantial violation on all 4 violations, this court must reverse the revocation because the record fails to establish that the trial court would have revoked probation and imposed the same sentence had it found that fewer than the 4 violations had been established by the state. It's our position that the record actually indicates that the state failed to establish that Mr. Smith actually committed any of these violations in a willful and substantial manner. An alleged violation is not willful and substantial where the evidence shows that the defendant made reasonable efforts to comply with the terms and conditions of his probation, and that rule is established by the Florida Supreme Court in the Carter case. This court reviews for abuse of discretion, and that includes a determination as to whether the trial court acted in an unreasonable manner in revoking probation. Here, it's our position that the record reflects that the trial court acted unreasonably in concluding that Mr. Smith committed 4 willful and substantial violations and in imposing a sentence of 12 years in prison. The burden was on the state, not the defendant, to show that the alleged violations were both willful and substantial, and inept or negligent conduct on part of a defendant does not constitute a willful and substantial violation. In the instant case, we would concede that there may have been inept or negligent actions by Mr. Smith, but it's our contention that there was no evidence of deliberate efforts to violate probation.
What was the negligence?
The negligence would have been, for example, the second curfew violation, not contacting the probation officer before he went to sleep on the couch and oversleeping past the curfew time of 10 p.m. Or the second time, the first curfew violation, not making more efforts to contact the...
It doesn't all boil down to the fact that the trial judge in this particular case just simply believed the state's witnesses and didn't believe your client's version of events. Isn't that what it all boils down to?
Judge, I would respectfully disagree. I think the only conflict, the credibility conflict, was on Mr. Smith's explanation about whether he made some admission about the driving logs. I think on the curfew violations, especially on the first curfew violation, both parties were in agreement on what happened. In fact, the probation officer indicated at the hearing that he investigated Mr. Smith's explanation.
Well, here's what the trial judge said. You were not truthful on your logs. And then the trial judge said, and I'm quoting, you admitted that you screwed up and you were not truthful on your logs. I mean, that's what the trial court found. That's what the trial judge actually said that. So, I mean, so he just didn't believe your client's version of events. I mean, so what do we do with that? We say that the trial judge was wrong and came to the wrong conclusion in judging the credibility of the witnesses here? And how do we do that?
Your Honor, I believe you correctly cited the record and that the trial court did make a credibility determination as to the driving logs. I don't believe a similar determination was made on the alleged violations concerning the curfew violations.
Oh, one curfew violation, and I'll quote again. You knew that this is what the trial judge said. You knew that you had a curfew. You had a lady visitor for the evening, and it appears that she wanted to go because of all the noise that was there, not because of her illness. So the trial judge didn't buy into this illness story. He thought that there was a lady visitor that wanted to go because of the noise, and he took her. Violated the curfew.
Your Honor, our contention would be that the record does not support that conclusion. Even the probation officer indicated that he investigated this situation with the ex-wife and believed and found it to be valid, this excuse, and at one point even testified that he believed that he instructed Mr. Smith that there was an emergency exception to this curfew.
Well, the trial court responded to that. Well, you know, there are ways that you can have her taken home. For example, call a cab if she's ill. I mean, the trial court said, I really don't believe that story, but even if it was true, there are other means of transportation available that would have taken her home if she was actually ill.
I understand that the trial court did.
The trial judge said that.
The trial court did mention a taxi cab and did say there was other ways of doing so, but the probation officer testified that he instructed Mr. Smith explicitly that there was a curfew of 10 p.m. and that there would be emergency exceptions, and also testified at the hearing in this case that he believed that this situation did meet that emergency exception. So Mr. Smith's actual probation officer conceded at this hearing that
you would have to have the trial court believe the story. The trial court apparently just didn't believe the story that this lady was ill.
Well, as regards to that, I believe the trial court's conclusion on that is not supported by the record, because the probation officer actually investigated the story and concluded that the story was correct, investigated with Miss Smith that she did have cancer, was receiving treatment, confirmed that Mr. Smith's residence was noisy, and that he did return shortly thereafter. Even if there were, we would concede that there are other ways that Mr. Smith could have transported his ex-wife home, we would argue that the violation was not substantial in nature, given the short time he was away from his home and given the instructions he was provided by his probation officer. So we'd argue that violation was not willful and substantial and should not support the revocation of the probation and the 12-year sentence that was imposed. As to the second curfew violation, it's also our contention that the defendant's conduct, again, was negligent and inept, but not...
Is that the situation where he claims that he took some medicine because of his teeth and just fell asleep on the couch?
It is, Your Honor.
You think the trial judge bought that story too?
I don't believe he made a factual finding on that particular violation. So, and I don't believe we have any evidence in the record to refute that, other than the probation officer's testimony that the defendant called him shortly after the curfew and told him he had fallen asleep on a friend's couch, which is consistent with the testimony of Mr. Smith at the probation hearing. So, it's our contention that the record again shows inept or negligent conduct. Obviously, Mr. Smith should have conducted himself a little differently, but I don't believe it establishes a willful violation or a substantial violation on the curfew allegations. And there's case law to support our contention, including the McRae case from the 3rd DCA and the Boatwright case from the 3rd DCA, where individuals were in areas or in locations where they're not supposed to be without permission of the probation officer, but the courts concluded the violations in question were not willful and substantial, and believe that the facts of this case are analogous to those situations. That we only have, again, inept conduct or negligent conduct, but no willful or deliberate effort to avoid the conditions of probation. Again, Mr. Smith was driving home from work apparently between 4 and 5 p.m. His curfew wasn't until 10 p.m. Laid down to go to sleep at 6. Didn't intend to sleep for 4 hours, and upon waking up called his probation officer, which was confirmed by the probation officer at the hearing. So there is testimony in the record from the probation officer that does confirm the explanation provided by Mr. Smith. So, although I would agree with Judge Sawaya, your indication that the judge did not believe Mr. Smith's explanation as to the driving logs, I don't believe that the record supports that conclusion on the two curfew violations. And since the revocation and the sentence were based on all four, we'd ask the court to reverse the trial court's decision and remand for reconsideration of the sentence in this case. And I'll reserve the rest of my time for rebuttal if that's okay.
All right.
May it please the court, my name is Anthony Golden with the Attorney General's Office, representing the appellee of the state. The defendant, the appellant here, was originally charged with capital sexual battery and 3 counts of lewd molestation of a child. This is the child of his ex-wife, the person with whom he was, the 3 of these violations involve her. The reason that we feel this is willful and substantial is because the probation officer indicated, I want to know if he's with his ex-wife because the daughter, the victim, lives with her. 2 of the log omissions were visits with the ex-wife at her residence. We don't know if the victim was anywhere around, which would have been another violation. In any event, the defendant was put on probation in January on a reduced charge, 1 count of lewd conduct with a minor. And the 4 violations, 2 were in March, 1 was in August, 1 was in December. And in revoking the probation, Judge Perry said, you should have been given this gift, and he referred to this plea as a gift, you should have been following all your conditions of probation to the letter. And going through them one at a time, obviously he didn't do that. His ex-wife wanted to ride home, it was past his curfew, I'll ignore that condition. The 2 log violations, well, I'm not going to put those down. He admitted he didn't put them down, and the judge agreed with him on that. As for the last violation, the falling asleep on the sofa and staying out past his curfew, he said he went to the dentist. The records indicated he went on December 5th, and then he's taking oxycodone and hydrocodone for pain on December 10th, the day of the violation. I just don't feel that Judge Perry believed any of his excuses for any of these violations, and we would request that the order and judgment and sentence be affirmed.
Okay. Thank you, Mr. Golden.
May it please the court. The state in its brief, and again here today, seems to at least imply that there may have been some contact between Mr. Smith and the victim of this case, and the record actually reflects that not to be the case. The probation officer testified specifically in the record that he confirmed that there was no contact with the victim, that's pages 21 and 22, and that he also testified that although there were, in his opinion, omissions on the driving log when Mr. Smith was visiting his ex-wife's residence without documenting it, that Mr. Smith was not hiding his contact with his ex-wife and had actually listed several other times when he was at that residence. So, and again, this appears to be an omission or some negligence, but no deliberate effort to hide this contact with his ex-wife. And again, I can't say this enough, the probation officer agreed with Mr. Smith that this was an emergency situation to take his ex-wife home because she was sick, and agreed that that was one of the exceptions he told him about when he instructed him on the conditions of probation. So I find it hard to believe it can be a willful and substantial violation when the probation officer told Mr. Smith this was an exception, and after the fact even agrees that it fit the exception.
Does that bind the trial judge? Can the trial judge make his own conclusions?
The trial court can make his own conclusions, Your Honor, but I believe that his conclusions have to be based on the evidence here, and the evidence shows that that the probation officer instructed Mr. Smith, you have a 10 p.m. curfew unless there's an emergency situation.
It was an intentional violation, wasn't it? When he took his ex-wife home. I mean, he knew he was leaving his house. The sex offender laws require that you be home from 10 to 6. He knew he was leaving after 10 and before 6 to take her to her house, when he had other means to take her there, or get her there.
Well, Your Honor, he did know he had a 10 p.m. curfew, and he agreed to that and conceded that at the hearing, but his probation officer...
The statute requires that, though, doesn't it?
I'm not sure the
Sex
statute
offender
requires...
probation requires a curfew from 10 to 6.
I'm not sure if it does or not. I know that in this specific case, a condition of probation was a 10 p.m. curfew, and I don't believe anyone disputes that, including Mr. Smith. I believe the relevant question, Your Honor, is what exception was he informed of? The probation officer testified he informed them that there was an exception for emergency situations. Mr. Smith apparently made a decision that this was an emergency because his ex-wife was receiving cancer treatment and was feeling ill and drove her home. And after the fact, the probation officer concedes he instructed him that there was an exception for emergencies and agrees that this was an emergency. So the person that told him what the conditions were agrees that this was an exception. And it's our position that the evidence before the trial court did not show that Mr. Smith was a man trying to avoid the conditions of probation, that he was caring for his ex-wife who was receiving treatment for cancer. He was actually going to work on days when the dentist had excused him from going to work because he was trying to make a living, and that's when he got in this situation with falling asleep on the couch. He was just trying to live paycheck to paycheck and, pulled off the road because he believed it was a danger to keep driving while he wasn't feeling well. So we have a man who was making reasonable efforts to comply with the terms of his probation and did not commit any willful and substantial violations. Again, we would cite the Boatwright case as an analogous situation, and we believe that although there may be some support for the driving logs, that the other two violations are clearly not willful and substantial based on the evidence presented by the state, and because there was insufficient evidence that the trial court would have revoked and imposed a 12-year sentence without a finding on 4 violations, that the court reversed the trial court's decision or remand for further proceedings. Thank you.
Thank you, Mr. Pennell.